heard appeals in the matter of Queeld Ventures and others and Vesnin.
There's a certain amount of musical chairs and a slightly smaller crowd.
I hope the latter has nothing to do with me being on my feet, my lord. Good morning, my lords, my lady. Before I open my appeal, I understand Mr. Harrison wants to make a small correction to submissions from yesterday.
Right.
My lords, my lady, it's a very small point. At the end of yesterday afternoon, I addressed the question about the skeleton arguments from the trial and the public availability of those. And I referred to the order made at the pre-trial review by Mr. Robin Voss, sitting as a deputy judge back in October 2023. And we've tracked that order down and a copy has been put in front of the court. And there are 2 points just to mention very briefly. At paragraph 5, the court will see if my recollection was correct, that the trial was to begin on the 13th of November, which is a Monday. That was the judge's reading day, and the matter then settled by the Tomlin order on the following day, the Tuesday, the 14th. So we didn't actually begin in court with the parties, but the judge was reading on the Monday, the 13th, including the skeletons. And the second point to clarify, looking at paragraph 3, is that my recollection was wrong when I thought the skeletons had been covered by a protective order imposing a restriction under CPR Rule 5.4c. And in fact, that restriction applied only to the statements of case and the evidence, but not also to the skeletons.
Okay. Thank you very much. Yes.
This appeal arises out of the decision by Chief ICC Judge Briggs, sitting as a judge of the High Court, to refuse to hear from Queeld and Myspare, Q&M as I'll refer to them, on an application made by Mr. Vesnin for recognition at common law of the bankruptcy order made against Mr. Ananyov in Russia and Mr. Vesnin's appointment in Russia as Mr. Anyonyov's trustee in bankruptcy. The judge held that Q&M had no standing to oppose the application for recognition and made a recognition order without giving them the opportunity to file evidence or to advance argument on the application. And your lordships and your ladyship will have seen from our skeleton argument that that was so notwithstanding that Mr. Vesnin had named Q&M as respondent to the application, which sought both recognition and assistance from the English court, that Mr. Vesnin had sought and the Chief ICC judge himself had granted permission to serve Q&M out of the jurisdiction, and that Q&M had participated on the application on the basis that they were respondents to it and had been validly served with it. Further, at the hearing, the ICC judge queried the standing of the respondents at a hearing at which Mr. Justice Mead had directed that 4 specific issues be the issues for determination on that occasion, and none of those issues related to the respondent's standing. Having done that, the ICC judge also ordered Q&M to pay Mr. Vesnin's costs thrown away by reason of their participation in the recognition application that he had made against them. In attempting to defend this position, my learned friends argue, first, that Mr. Vesnin's application sought 2 quite separate things, recognition of the bankruptcy on the one hand and judicial assistance on the other hand, and secondly, that the judge was correct to hold that Q&M didn't have standing to participate on the recognition part of the application because they had no legitimate interest in the bankruptcy. Now, we contend that whilst recognition of a foreign bankruptcy and judicial assistance to a foreign trustee are separate and distinct concepts, recognition is the gateway through which assistance can be sought, and that a person against whom the assistance is sought has standing to oppose recognition or to apply to set aside a recognition order because they have a legitimate interest in only being exposed to orders made to assist the trustee if the trustee is properly entitled to recognition, recognition being the gateway to assistance. Now, with that said by way of very brief overview, and subject, of course, to your lordships and my lady, I intend to structure my oral submissions as follows. First, I'd like to take you through the key documents to show you the application, the evidence in support of it and the orders made. Secondly, I'd like to explain that whilst recognition and assistance are different concepts, they are inextricably linked, so as to give a legitimate interest in the recognition application to the target of the judicial assistance. Thirdly, I would like to show you an example in the context of the Cross-Border Insolvency Regulations 2006 of the court allowing persons who were the intended targets of judicial assistance to apply to set aside a recognition order. Fourthly, and depending on whether we have time for me to do this fully, I'll explain why the authorities that my learned friends rely upon to suggest that outsiders to the bankruptcy don't have a legitimate interest to access certain statutory provisions are not determinative of the position on a recognition application. Fifthly, I will take you to a decision of Chief ICC Judge Briggs, the same judge, where he took a fundamentally different approach to the authorities which he relied upon in reaching his conclusion in this case. Sixthly, I will then show you where he went wrong in the judgment below, including in not following his own earlier decision. And seventhly, and finally, having focused until that stage...
Was his earlier decision as a deputy taken as a deputy?
I don't think it was. I think it was...
So he wouldn't have been bound by then?
Not strictly, no, but it was the right approach, and he distinguished the authorities and then...
You're not saying he should have followed it because he was bound by it?
No, just let me double check, my lord, but that wasn't the submission that I had intended to make. He was sitting as a deputy High Court judge on that occasion.
In both? So in
He was
both.
sitting as a, well, it's recorded as him sitting as a deputy High Court judge in the first case.
And you say, therefore, he should have...
Actually, as a matter of precedence, unless persuaded he had got it wrong, he probably should have followed it. It's a matter of precedent as well as because it was right. I was just outlining the seventh thing I was going to do, which is having focused entirely on ground one of the appeal, which is the key ground of the appeal. I was going to very briefly take you through the other grounds of the appeal that we rely upon as well. So that's what I do intend to deal with. In terms of what I don't intend to deal with at this stage, I don't intend to deal with the respondent's notice that has been filed by Mr. Vesnin. Firstly, it's appropriate for Mr. Davies to deal with his respondent's notice first and for us to respond to that. And secondly, Mr. Edwards is going to make the submissions on the respondent's notice, Mr. Edwards having appeared below and I having not appeared below. The other thing that I don't propose to do is to make submissions on the issue of the status of a recognition order in terms of whether it only binds the parties to the order or whether it binds, in simple terms, the world. Our submissions will proceed on the basis that a common law order recognising a foreign insolvency process and foreign insolvency office holder is binding generally, such that for the purposes of the appeal, we are lumbered with the recognition order unless and until set aside by this court or otherwise. So I said I'd start by taking you through the court documents. Can I do that by starting with the application itself? Just in case it helps, the documents that I'm going to be taking the court to are either found in the core bundle or the second volume of the supplemental bundle. For purposes of my submissions, you will only need those two bundles plus the 4 authorities bundles, the fourth one being the 3 additional authorities that we put in. So if we could start, please, by turning up tab 25 of the core bundle. This, beginning on page 323, is the application notice, which is the originating process by which the recognition order was sought. And you can see on page 323 itself that the application was made under the common law and was said to relate to Part 9 of the Insolvency Act 1986. That's the bankruptcy part of the Act. And the parties are identified, including Q&M, as the two respondents. Turning over to the next page, page 324, you'll see at the top of the page 3 numbered paragraphs where what the application concerns is summarised by Mr. Vesnin. And I'd be grateful if you could just skim read, please, those first 3 paragraphs. Thank you. And if you've done that, the precise relief sought is then identified 2/3 of the way down the page. And paragraph 1 is an order recognising the bankruptcy order and the appointment of Mr. Vesnin. And then paragraph 2 is the assistance paragraph, which is such assistance and relief as the court sees fit, including insofar as necessary. And then paragraph A, which focuses on the shares in the respondents themselves. And then B, an order for delivery up of the replacement certificate, which is a defined term from numbered paragraph 3 towards the top of the page, and or restraining the respondents from dealing with their own shares and or the replacement certificate and or their respective shares in Eurasia Mining PLC. So paragraph 1's dealing with recognition, paragraph 2 is dealing with assistance. It deals not only with the replacement certificates, but the respondents, the shares in the respondents and the shares in Eurasia more generally. And then just to complete what's sought over the page, further or other relief and costs in the usual way.
I'm not sure why B, I mean, it doesn't matter for you, but why does B seek an order restraining them from dealing with their own shares? What does that mean?
My lord, I don't know, and I'm afraid I can't really help with that. We're going to turn to some of the evidence in a moment. I'm just showing you at the moment.
It seems to fit more within A. A seems to be dealing with their own share capital.
Yes.
I'm just not sure why those words appear in B, which seems to be dealing with the shares in Eurasia.
They may be superfluous. It may be they can be struck through,
I'm
and
not missing
effectively the
anything.
relief source is the
I'm
same.
not missing anything special around it.
Mr. Davis will know better than me, but if you are, I am too.
Okay, right, good.
Turning on, if you're not already there, to page 325, you'll see that it was Mr. Vesnin's intention to serve Q&M with the application and to give notice of it to Eurasia, Mr. Ananyov, his wife, and one other person. So one can see clearly that the application was made against Q&M. It sought recognition and assistance, recognition being the prelude to the assistance, and it did so on a rolled up basis. And Lords, there is, and my lady, there's nothing on the face of the application to suggest that Q&M were respondents to the application only for the purposes of paragraph 2, or that paragraph 1 would be sought first in their absence and then they would appear for the purposes of paragraph 2 or anything like that. The next document I want to take you very briefly to is the witness statements filed in support of the application. You'll find that in volume 2 of the supplemental bundle. Can we start, please, at tab 29? So this is a witness statement made by Mr. Beckwith on behalf of Mr. Vesnin, the applicant. And the relevant part of the witness statement starts at page 401 of the bundle using the numbering bottom right. You'll see at paragraph 35 the basis of the application is summarised, and then each of the 7 points summarised in paragraph 35 is then dealt with in the balance of the witness statement. So, does my Lord Justice Snowden have?
And now it's in the right volume, sorry, Fall 2.
So yeah, volume 2 of the supplemental bundle.
Yeah.
Now, I don't need to take you through this in detail. We don't have time. There are 2 points that I want to highlight. Firstly, on page 404, we'll come back to the relevance of this in due course. At paragraph 47 of the witness statement, an explanation is provided as to why the application seeks relief at common law and was not made under the CBIRs, if I can refer to them as that. And it appears that an application under the CBIRs would have failed because Mr. Ananyov's Coney had not been in Russia at the time of his bankruptcy being opened, neither did he have an establishment there at the relevant time. And that's why the application was made under the common law rather than under the CBIRs. The second point I wanted to draw to your attention is on page 406. And it's paragraph 55, where an explanation is given by Mr. Beckett as to why the recognition application has been made against Q&M. I can ask you please to read paragraph 55 to yourselves.
Yeah.
And again, so far as I could see, there was no suggestion in the witness statement that Q&M were parties to the application only for the purposes of assistance and that they had no standing or role to play in relation to the recognition part of the application. And in fact, paragraph 59 sets out that the applicant respectfully requests recognition and, if granted, the following relief, being the assistance. Now, turning to the next tab, tab 30, Mr. Vesnin himself additionally made a witness statement in support of the application. Again, I'm not going to take you through it in detail, but can I please show you paragraph 75 on page 426? And it's clear from paragraph 75 again that the purpose for which recognition is sought is to be able to seek relief to ensure that the replacement certificates don't find their way into the hands of entities associated with Mr. Ananyov. There is an additional purpose that's identified on the next page, 427, in paragraph 78. It is also considering the possibility of petitioning the English court for an order to freeze the assets of Mr. Ananyov or to declare him or his wife bankrupt in England based on the decision issued by the arbitration court of Moscow. In the first instance, I wish to be recognised that I can seek the assistance of this court. So recognition is the gateway to assistance. The assistance sought at this stage relates to the Eurasia share certificates, but an additional purpose is identified in paragraph 78. I don't believe that purpose has been pursued since, but I'll be corrected if I'm wrong. And then paragraph 79 in the summary section paraphrases the relief sought that you've already seen from the terms of the application itself. If we could turn to the next tab, please, tab 31. At the bottom of page 429, you will see that the first return date of the recognition application was originally going to be the 5th of March 2025. And turning over the page, that it was relisted pursuant to this order of James Morgan KC, sitting as Deputy High Court Judge on the 8th of November, so that it was listed in the interim applications list for directions only on the 15th of November 2024. And that was made on an application by the applicant, Mr. Vesnin, with Mr. Davis appearing, seeking to bring the date forwards. Now, the reasons given for bringing the date forwards were identified in Mr. Beckwith's second witness statement, which you'll find in tab 32, the next tab of the bundle. And can I ask you please to turn to page 434 and read paragraph 12 to yourselves, please. And the simple point I make on the basis of that is it's absolutely clear that the principal purpose for which recognition was sought was wrapped up in the in Mr. Vesnin's desire that the replacement certificates be not released from the undertaking. Now, the witness statement we're currently looking at.
But is this right? Sorry, two things.
Yes.
That at Roman 5, it is suggested that the Queeld hearing, that the respondents persuaded the court, that's your plans, that Mr. Vesnin had no sufficient interest to object to the release of the Eurasia shares to the respondents without recognition or prior to recognition. So in a sense, both sides were focusing on recognition as being a key question which had to be resolved.
Yes, later on, and learning from Mr. Edwards will give us the reference if necessary, the respondents gave an undertaking not to rely on before Mr. Justice Mead, they gave an undertaking effectively not to attempt to argue that Mr. Vesnin could play no role in the proceedings prior to being recognised. So it's the Mead order. It's at tab 37 of this bundle.
Okay, I don't want to take you out of your course.
That's fine, my lord. Just to give you the reference, it's an undertaking on page 506, and it's the penultimate recital. So, and upon the respondents confirming to the court that in the event that the applicant should make an interim application under paragraph 12, they will not oppose that application on the basis of arguable case or risk of dissipation or standing, and may only oppose on the basis that a fortified cross undertaking must be given, or that the absence of such fortified cross undertaking is a reason to refuse the relief sought. So that's what happened next in relation to that point. But yes, the point is that recognition and the share certificates were very closely related issues in the sense that it was Mr. Vesnin's application for recognition that gave him standing to contest what should happen in relation to the share certificates.
And just to be clear as well, going back to the previous order for me, sorry, what's there is there defined as the recognition application.
Yes.
It seems to be, that's the application dated the 5th of November, which I think is one we were looking at.
It's the one I showed you, which is at tab 25 of the core bundle.
Yeah, but it seems to be only dealing with the bit about recognition. This doesn't seem to be suggesting that the other relief that is flagged, i.e. the paragraph 2 relief is people weren't focusing on the paragraph 2 relief. I mean, there were 2 paragraphs you showed us.
There are.
1 recognition, 2 other assistance.
Yes, in the context of that order, that's
so
right.
this order, in front of Mr. Morgan,
Yes.
was what only dealing with paragraph 1 recognition.
Well, he's only defined the application with reference to paragraph 1 of it. I have to accept that.
I'm not making a point. I'm just
Yeah.
trying to make sure I'm on the same page as everybody else.
My lord is right, that's what it says. Now, we were just in the second witness statement of Mr. Beckwith. I know just showing you paragraph 12 to show you the linkage again between recognition and assistance. But what I wanted to just explain is that this witness statement was made in support of the application for leave to serve the recognition application on Q&M out of the jurisdiction. And as you can see, if you turn please to page 436 and look at the bottom of the page, section C of the witness statement, Mr. Beckwith is here identifying the basis upon which it was said that there was a good arguable case that recognition at common law is available. And can I ask you just to read paragraph 21 to yourself? It's only 1 sentence. As part of seeking permission to serve out, a good arguable case on recognition is sought to be made out. And then if one could turn please to the next page, 437, and look at paragraph 25, you see again the point as to why an application is being made at common law and not under the CBIR. The purpose of the recognition application is then set out on in paragraph 26 on the next page, page 438. The purpose of the recognition application is to prevent the respondents from dissipating the value of the Eurasia shares before the applicant can claim them from the bankruptcy estate. As such, the subject matter of the recognition application relates principally to property within the jurisdiction, so falls within property within the jurisdiction gateway. So, again, there is a conflation of recognition and assistance, or an appreciation that the purpose of seeking recognition is all about the assistance that Mr. Vesnin can seek flowing from that, including paragraph 2 of the application notice. The purpose is again spelt out in paragraph 33 on page 440. Again, recognition sought to object the issue of the replacement certificates to the respondents. Just in passing and turning over to page 443, Mr. Beckwith notes in paragraph 42 that the respondents may seek to challenge the recognition application on grounds of fraud, breach of natural justice or public policy. And he says such arguments not available to the respondents, and he does that with reference to evidence. He doesn't suggest that they're in fact shut out from making those arguments because they have no standing to make them. Behind the next tab, tab 33, is the skeleton argument relied upon on the service out application. I can ask you please to turn to page 453.
So you say that the paragraphs 43 to 55 deal with merits, not standing. Is that right? In summary, I mean, he says rather than evidence, which he repeats, and he sets it out 43 to 55, you say none of that takes a standing point.
Yes.
So he's saying not available because, well, they're just not good arguments, presumably.
Yes.
Right. and he says this was addressed in 29 to 30 the applicant's skeleton. Is that just in, you haven't got that, or you haven't taken us that? Is that the same point? Doesn't make a standing argument.
That's right. I looked at that.
Yeah.
So which paragraph of the skeleton are we in? 33, tab
I've
33?
just shown you on page 443 of the bundle, paragraph 42 of the skeleton argument. Sorry, paragraph 42 of the evidence. We were turning next, sorry, to the skeleton argument, tab 33, I apologise.
Yeah, that's right.
And I was looking at page 453,
Thank you.
under the heading Good Arguable Case, what is said in that regard. And it wasn't suggested that the test of good arguable case didn't need to be met in relation to recognition on the basis that Q&M had no interest in that part of the application. So good arguable case is dealing with the availability of common law recognition, which wouldn't need to be addressed on a skeleton argument for permission to serve out if paragraph 1 was in fact not relief that was being sought as against Q&M. If my lady could please turn to page 459 and turn to paragraph 29 of the skeleton argument. There, my learned friends identified 8 arguments that might be raised by Q&M on the recognition application. And if one has a quick read through those.
So just, you took us. So I'm just trying to catch up. You took us to page 435. Sorry, 453.
Yes.
Sorry. I mean, 457 seems to, paragraph 24 seems to be relevant as well, doesn't it?
Which paragraph, my lord, sorry?
24.
Yes.
And that's of a piece with the submissions you've been making, I think.
Yes. Lord, I was asking you to look at paragraph 29 next, where learned friends identify arguments that may be raised by the respondents.
Yeah.
And when one looks through them, it's certainly clear that not all of these points are limited to the assistance part of the recognition application. For example, sixthly, at F, which is that the proceedings before the Russian court are politically motivated. So it's envisaged, for example, in the sixthly, that the respondents may raise an argument that the recognition application should be dismissed on the basis, effectively, of public policy.
As a ground for opposing recognition.
Well, it says arguments that might be raised by the respondents, but it's clearly, in my submission, directed at the recognition part of the recognition application. So
I'm just looking at sixthly.
Yes.
Insofar as this point is understood, it is that the recognition application should not be granted.
Yes.
Yeah.
Which would be sort of, I mean, as a general proposition, one ground for opposing recognition is that the bankruptcy order was based upon a judgment or was itself obtained by fraud or in breach of natural justice or contrary to English public policy.
Quite. And to leap on a point that my Lord made earlier in relation to a different document, but this also addresses my Lord Justice Coulson's point, if one turns back to page 449, the beginning of this witness statement, the term recognition application is defined, and again appears to be defined with reference only to paragraph 1 of the application, not paragraph 2. Therefore, where the term recognition application is used in the context of the sixthly on page 460, that lends further weight to the idea that this is something, an argument that might be raised in relation to recognition, not assistance.
Indeed, the paragraph discusses federal.
Correct.
Then finally, at page 461, the point is the respondents might suggest that the recognition should also be served upon the bankrupt.
Yeah.
Well, some of the parties said they might have the opportunity to be joined as parties to the recognition application. Trustee proposed to have no objection to those people joining. I fully understand why a bankrupt might be somebody who would be interested in the question of recognition of who, as it were, claims to stand in his shoes in this jurisdiction.
Yes.
I'm not immediately, it's not immediately clear what role or status the other people there might have, but at least on this application it's sort of suggested, well, okay, we don't care, that's fine, more the merrier, we can join them if they want to be joined.
Well, I think that's a fair point. I think I'd go slightly further than that and say that it's implicit in that those with entitlement to be heard on a recognition application are not limited to the bankrupt and the bankrupt's creditors.
Heard on this recognition application.
This recognition
I'm not
application.
sure I would extend that to.
My lord, that's a point well made.
Yeah.
Now, the application for leave to serve out was granted.
But just to press, because
Yeah.
what you're saying is, I mean, what you may get around to saying is, either generally the doors are open to a wider category of people than might otherwise be thought to be the case on a recognition application, or even if that isn't the case, as a general proposition, you'd say this particular application, the way it was teed up and set up and directed, it was perfectly appropriate for your times to appear.
Oh, that's right. We are not arguing that it's a free-for-all and anyone can pitch up on a recognition application. The point that we make, and I said this in opening, is that recognition and assistance go to an extent hand in hand, and where a recognition application is made for a specific purpose of seeking relief against a specific person, then that person, we say, has a legitimate interest or sufficient interest for the court to hear from them on that recognition application.
Certainly here you say recognition and assistance go hand in hand, and
Yes.
you've been showing us the documents you rely upon to support that proposition. I mean, as a general proposition, it isn't always the case that recognition goes hand in hand with assistance. It's, as you say, just simply the gateway. And in insolvency generally, a well-advised foreign office holder might decide at an early stage in proceedings, not knowing what's to come, to take the precaution of seeking recognition without any particular assistance in mind, but because they don't know what's coming.
My lord,
I mean, that supports
yes.
your proposition that the two are conceptually distinct, but may be linked.
correct. Turning to the CBIRs just briefly, obviously because recognition under the CBIRs brings with it an automatic moratorium in the case of a foreign main proceeding, it may be that recognition is sought for the purposes of getting a moratorium in place and potentially accessing other provisions later on that the office holder, the foreign representative, isn't quite on top of yet.
Yeah.
It is, though, quite common for recognition applications to be sought with a specific form of assistance in mind. And when it comes to common law recognition...
Because most office holders have a limited amount of cash and they don't
Correct.
just do things for, it would be nice to have, but I don't know why. But conceptually they're distinct. Often they're linked.
Under the
often-
CBIRs, there may be a good reason for getting an early recognition order to get the moratorium and to have the toolbox available. With common law recognition, it takes time, effort and money to apply for common law recognition. And common law recognition of itself doesn't give you anything concrete. And therefore, common law recognition is more likely to be sought with specific assistance in mind, as was the case here. Now, none of this much matters to the essential argument, because the essential argument is, on an application such as this, where there is a clear purpose for seeking recognition, and the clear purpose is to access assistance against a respondent or to interpose oneself in the respondent's litigation, the respondent has an obvious interest in ensuring that recognition is only given if the test for it is met and there's no good reason for not recognising. That's the simple point at the heart of our submissions. And I will show you, when I get there, an example in the context of the CBIRs, which is analogous to this case. And I'll also show you what the very same judge said on another case about why people should have standing on recognition applications based on the consequences of recognition being granted.
Well, that's the excitement of your number 5.
Yes.
But we're still in the foothills of number 1. So
I will try and speed up, my
do
lord.
carry on.
I apologise. The order for leave to permission to serve out is at tab 34. By paragraph 5 on page 463, the judge ordered the application, the recognition application, to come on an expedited basis with a time estimate of 2 days. And Q&M were then served and responded by making the application at tab 36, by which they sought to challenge the court's jurisdiction in respect to paragraph 2A of the recognition application, the first head of the assistance part of the relief, and to set aside or vary the directions included by the ICC judge in his order granting permission to serve out, on the basis that an expedited 2-day trial just would come too soon.
But that's where things, this is why I, in a sense, asked the previous question. If you look at the order that we just looked at 462, the previous order, in fact, and this one,
Yes.
462, it's upon the application for recognition. And I appreciate this may be simply shorthand, but the application at tab 36, starting at 502, seeks to attack the assistance bits, not the recognition bits.
That is right.
And are people, I mean, is that, I mean, was the, you haven't taken us through the evidence, I'm not suggesting you should, but was the evidence that was filed in support simply of recognition, or was it filed in support of paragraphs 2A, 2 and 2A?
I understand the question. It may be, although it wasn't made explicit, save potentially with reference to the way that the term recognition application was defined, that it related only to recognition and not assistance. I find that, though, a little surprising in the sense that paragraph 2 was in the order. Paragraph 2 was part of the assistance that was sought. The chief
Paragraph
ICC
2 was in the order.
Sorry, it was in the application. At the end of the day, paragraph 2 was treated as being before chief ICC judge because he gave relief in relation to it.
What I'm trying to sort of, perhaps I can ask the question this way. Was the evidence that was filed in support of the application to which permission was given to respond by paragraph 6 of the order you've just shown us at 463, was that evidence just directed at recognition, or was it going wider and saying, you know, these are orders that we want by way of assistance? I mean,
Can I ask Mr. Edwards to check? The problem is that there is nowhere is a clear distinction made, and obviously the purpose behind the recognition part of the application all related to the share certificates. And it's slightly bizarre for the argument now to be made that recognition and assistance are two completely separate things and should be kept separate.
Okay.
If it's the case that all of this was only directed at recognition, because then why get leave to serve out on something that the respondents have no standing to appear on?
Perhaps I can ask the question in a different way.
Yes.
The applicants who are issuing the application at 502 are your clients.
Yes.
Right. So I think, legitimately ask you whether their intention or their purpose in issuing this application seeking those orders under A and B, or certainly A, was prompted by the fact that there was evidence and an intention indicated to seek assistance as well as recognition, or was this simply prophylactic in the sense that the evidence was only in support of a recognition application, but you decided to have try and cut it off at the pass by...
Well, I'd need to go back to the evidence to check, and I'll ask Mr. Edwards to do that. But if you look at the order of Chief Insolvency Companies Court Judge Briggs at tab 34, which is the order for permission to serve out, what he, at page 463 does is give permission to serve the recognition application out of the jurisdiction, and that is defined in the third recital on page 462 as the application of the applicant dated 5th of November for recognition under common law of the bankruptcy order.
Yeah. Which at least on the face of it might be thought to be limited to paragraph 1 if people were really focusing on the distinction between recognition and assistance.
Well, might, but I would suggest that it should be made very considerably clearer than that.
Yeah, so which is why I was asking you, what was the evidence in support? What was that addressed to? Because that might give you some clue. Because if it was only directed, I mean, we can go look at it, but it's just I haven't had the time to go and start reading it through.
I understand the point, and learned friend will help me with this. As I have read the evidence previously, it does get into at least paragraph 2b in the replacement certificates. It's a bit difficult to see, when it's certainly not said, that the evidence was strictly limited to the question of recognition.
Okay.
And I don't think anyone has proceeded on the basis that all that has been served on the respondents is, in effect, the recognition application shorn of paragraph 2.
No. I'm sure that what's served is an application containing 1 and 2.
Yes.
I'm more concerned with, at the moment, just understanding, and it is really only understanding what Chief ICC Judge Briggs thought he was, sitting as a deputy judge, thought that he was doing when he adjourned things with a final hearing listed with an estimate for 2 days. Because on the face of it, you would have thought that 2 days might be appropriate for a recognition application simpliciter. But if it was for all the other potential assistance, unspecified assistance, etc., under paragraph 2, given the history, 2 days seems a little bit thin.
Well, it depends what was actually going to be asked for in terms of assistance. I mean, what we'll come to is what was granted, and it's very limited. So I'm afraid I think it's difficult to take much from the time estimate. The next order I wanted to show you is the next tab, the order of Mr. Justice Mead of the 18th of December 2024, so tab 37. And if you could turn, please, to page 507, you'll see that what he ordered was that the final hearing of the recognition application listed on the 15th of January is vacated. And he then directed 4 specific issues, not including standing, to be determined at that hearing before Chief ICC Judge Briggs. So what was taken off the table was the substantive recognition application for that hearing, and it was replaced by the 4 items for determination listed in subparagraphs A to D. I mean, that's why on the 15th, when the 15th of January hearing came before the court, in fact it started the day earlier on the 14th of January, counsel for Q&M, Mr Edwards, was ready, willing and able to deal with those 4 items listed effectively as agenda items in paragraph 3 of the order of Mr Justice Mead, but not necessarily to deal with the question of standing in circumstances where the respondents had been made parties to the recognition application and leave to serve it out of the jurisdiction on them had been sought and obtained. Nevertheless, the Chief ICC judge asked what gave Q&M standing and stated that the answer was not that they had been made respondents to the application, and he ultimately decided that they had no standing, such that no directions were then given for further evidence or argument on the recognition application, and the judge acceded to the recognition application at that hearing. Now, can I just show you one extract from the transcript on this? It's at tab 39 of the supplemental bundle. And could I ask you please to turn to page 523. And you'll see at line 24 at the second hole punch, the judge says this to Mr Edwards: "Now I want to know, I'm afraid, it may be that I'm being very stern. I want to know what the standing is, and the answer that we've been made respondent by the trustee does not give you standing. It's a matter for the court, and that is what I'm interested in." Now, as to the orders made by Chief ICC Judge Briggs, could we go back, please, to the core bundle and paragraph 20 to start, sorry, tab 20 to start off with.
Sorry, I was just noting a chunk of the transcript. Go back, give me the reference again.
It was lines 24.
No, I've looked at that. Sorry, you were then moving on.
Sorry, tab
and I
20
missed
of the core
reference.
bundle, please.
Tab 20 of the core bundle.
So this is the recognition order.
Yeah.
And the material provision of the order is on page 284.
Just before we do get there, because we're going to another file,
Yes.
just trying to understand what Mr Justice Mead's order contemplated. There was something defined as the jurisdiction application, which I think is your application, which we were looking at, contesting jurisdiction in relation to the claim for release specified in paragraph 2A of the recognition application.
Because that involved the shares in Q&M themselves, which are outside of the jurisdiction.
And so that was the point that was being made, because we hadn't. The issue that you were saying is that paragraph 2A relates to assets outside the jurisdiction, so there's no basis for getting involved. It doesn't presuppose that there had been recognition. It was a different objection.
Well, you only get into 2A.
Well, you just say, even if you had recognition, you just can't deal with this stuff because it's outside the jurisdiction.
And presupposes that what's been served is the full recognition application, not just paragraph 1, and that's before the court.
Yeah, no, I get it. I mean,
but yes, it's a jurisdictional challenge, which is, even if you're recognised or not, what on earth are you doing, including within your application, issues relating to shares in foreign companies.
Which would be why you didn't seek to strike out 2B.
Yes, even though, as my lord identified, there is a bit of 2B that perhaps might have been struck out as well, but that wasn't focused on.
Right. Okay, yep.
So we are now in the recognition order, tab 20 of the core bundle, page 284. And it's paragraph 2 on page 284, which is the order. And Chief ICC Judge Briggs ordered that the bankruptcy order and the appointment are recognised at common law. Paragraph 3 reserved the question of costs to the hearing on the 16th of January. But if you could turn please to the next tab, tab 21, you'll see what was ordered in relation to costs. And could I ask you please to read paragraphs 3 to 6 of that order on page 286 to yourselves.
Yeah.
And just for completeness, whilst we're on this order, you'll notice that in paragraph 1, and I'll come back to this, the jurisdiction challenge, which is the application that my Lord Justice Snowden was just discussing with me, was dismissed. Together with Q&M's application for security for costs, that was dismissed too. And we'll come back to that at the end. And then just finally, before I can start turning to my substantive submissions, could we go back, please, one more time to the supplemental bundle and turn, please, to volume 2, tab 40. You'll find an order also of the 16th of January made at that hearing where those 4 specific issues were meant to be dealt with. And at page 600, paragraph 1, the assistance that is given, and it appears that this is by way of effectively further or other relief, or the relief sought by paragraph 2 but not quite set out in paragraph 2 of the application notice, is that the applicant may participate in and shall be a party to the 2021 action for all purposes, including the determination of the issue and any appeal that may arise following the determination. So the assistance which the judge appears to give is that the applicant can join in the Eurasia proceedings.
So, sorry, I'm just trying to get these orders. You've taken us these orders actually slightly out of sequence. The order at tab 20 was the first order made on the 15th of January, where the judge made the order for recognition of common law.
Yes.
And he also ordered the respondents cease to be parties to the application. In other words, he took them off the application to which they...
At their application, on their application, I should say. So as I understand it, Mr. Edwards, when told that his clients didn't have standing, sought to extract them from the recognition application on the basis that then there would be an argument available that they weren't bound by it, and the judge acceded to that invitation.
Okay, so that happens on the 15th.
Yes.
So the next day...
The next day is the assistance, and I think the day after that may be the costs, but...
So the next day, the judge makes an order saying that the applicant, that's obviously Mr. Vesnin, can participate in the 2021 action, which is the action that your clients started against Eurasia.
That's right.
And he makes that order, what, in, how? I mean, what?
I mean, if you look at the third recital on page 599.
Yeah, but does he, for example, give, was there any notice, was there any indication that that was coming? I mean, did the Eurasia made aware of that was going to happen, or does he need to do that?
Apparently not, my lord. I wasn't involved at this time, but I'm told not.
Okay, so he just effectively he's just making an order in another action?
Well, that appears to be the assistance that he's granting under paragraph 2.
It's tied together with the order of the erasure action as well. So
Lord, it may be worth looking at tab 13 of the core bundle. Sorry, supplemental bundle 1, which I said you wouldn't need, but you do, I'm sorry. This is an order made by the same judge on the 17th of January as well in the Eurasia proceedings upon the oral application of Mr. Vesnin.
This is the one
It's
that
paragraph
removes
3, which is
removes the restrictions.
yeah.
In
So
paragraph
he
three.
brings before himself, I think. Well, it's already before him. He calls back on the Eurasia proceedings and makes this order
Okay,
at the same time as he makes the assistance order.
So the Eurasia proceedings were in front of him for some reason.
Apparently.
because of the injunction application, the injunction application was made in the erasure action.
The injunction application was made in the Eurasia application, and that was before him, pursuant to the Mead order.
Yeah, because of the existing.
Okay, so that's the piece of the jigsaw I was missing. That Mr. Justice
I mean-
Mead had ordered.
The 4 items.
I'm sorry. Okay.
So that's what that was what was done. I hope that was helpful, just in terms of identifying how things played out and what approach was taken by the applicants to recognition and the purposes for which it was sought. Can I now turn to recognition and assistance being linked concepts, certainly in the context of this application? In attempting to support the judge's decision in this case, my learned friends seek to make great play of there being a conceptual distinction between recognition and assistance. And what they say in their skeleton argument of paragraph 11 is that we wrongly conflate the trustee's request for recognition with his request for assistance. And with respect, we say that's not the case. There is, of course, a distinction between the two concepts. Recognition, on the one hand, gives the insolvency office holder the right to appear on behalf of the debtor's estate, to stand in the debtor's shoes, and it turns on his or her status as such and whether there is any good reason not to recognise that status. Assistance, on the other hand, is a generic term for remedies which the court might grant the insolvency office holder, once recognised, to assist him or her in their task. Now, whilst they're two different concepts, in practical terms, recognition is the gateway to assistance. And where a person against whom the assistance is sought has reason to oppose recognition in the first place, we submit that they must have the ability to make the arguments on recognition before the court.
Sorry, but you've added into that sentence. Can you just repeat it? Where you say where the person against whom.
Yes, where on an application for recognition assistance is also sought, or it is clearly identified in the evidence that the purposes of seeking the recognition is to seek assistance of a particular type. The person against whom that assistance is sought, whether it's a Section 236 application or similar,
Target, let's call it the target.
the target,
Or
the
intended target.
the intended target, we submit, clearly has an interest in tackling the position at the level of recognition and explaining to the court why it is that recognition should not be forthcoming.
Right, and when you say interest, you're going to develop this, but are you saying has an interest in the commercial sense of I wouldn't like to be a target of this person, or are you saying an interest in a legal sense, and if so, what's the legal interest?
An interest in the sense of being someone from whom the court should hear, because they are affected directly by the question of recognition.
But you don't generally get to choose who sues you.
My lord, that's right. But if you have if you're facing a claim from X, your contractual counterparty, you, when X becomes bankrupt, may face a claim from Y. But if you're going to face a claim from Y, who is not someone that you contracted with, you have an interest in the court being satisfied that Y actually has the status of being X's trustee in bankruptcy, and there's no reason why Y should not sue you.
Yeah, so that you, to use that example, if you're sued by someone claiming to be an assignee of a debt, you're saying that the question of whether they are in fact an assignee or in law an assignee able to bring the claim is something you should be entitled to say something about.
Yes, imagine a situation in which the assignee goes to court to get a declaration that the assignee has taken a legal assignment, and that the determination of that question in the absence of the debtor determines the point for all purposes, so that the debtor can't take issue with the validity of the assignment. You might think that that's a rather curious result. And the submission here is that the trustee is said to stand in the shoes of the bankrupt by way of assignment or similar concept. How can it be that Q&M have no ability to take issue with that? And we'll come on to this point that in relation, for example, to the cross-border insolvency regulations. I appreciate we are not in the territory of the cross-border insolvency regulations, but A, that's only because Mr. Ananyov did not have his Komiorn establishment in Russia at the relevant time. And in any event, it's very difficult to see why a different approach should be taken. Within the cross-border insolvency regulations, there is a specific rule that provides that the court can hear on an application for recognition, with the permission of the court, any other person who appears to have an interest justifying his appearance. And we say that that test is a test that applies equally in the context of common law recognition.
Which is the rule?
I'm going to take you to it in the context of down the IS step, but it's Schedule 2 of the CBIRs, and it's paragraph 25(1)J. A perfectly sensible test, particularly in the context of what recognition leads to in the opening of the assistant toolbox. But obviously, a sensible test to apply in a case such as this, where Mr. Vesnin wants to participate in proceedings standing in the shoes of the bankrupt, and Q&M want to argue that he shouldn't be able to do so.
The rule you've just taken us to is court may give permission.
Yes.
Is your case that you have a right to participate as of right? Maybe you say yes because you happen to have been made respondents, but
Yes, quite.
by way of parallel, let's say you hadn't been made respondents. Would you say, by analogy with that CBIR provision, there should be a discretion on the part of the court as to who it hears from?
Well, in a sense, having been made a respondent and having a clear interest.
I wanted to understand the position more generally.
Can I test it this way,
Yeah.
my lady? Let's assume that we hadn't been made a party to the recognition order, but we had applied to set it aside. The court would then need to satisfy itself that we have standing to make that application. And that would be I would submit, broadly similar test. Who is entitled to make that application? Someone with an interest that justifies them so doing.
I mean, the classic situation, I'm just looking for that, the classic situation in which that has come up is where, for example, is an arbitration proceeding in London between a company and a defendant, or well, probably the other way around, but in any event, one of the parties to the arbitration goes into a foreign insolvency process. and seeks recognition here with a view to claiming the moratorium against continued pursuit of the arbitration proceedings against it.
Yes.
And the question is whether the counterparty to the arbitration proceedings, if they get wind of the application, should be entitled to be heard on the application for recognition, or whether they have to wait until recognition has already taken place and then come in at a later stage to say that actually the court ought not to enforce the moratorium against them in relation to those proceedings. I mean, that's the sort of scenario we're talking about, isn't it? Or am I completely off?
Well, it's not dissimilar. I mean, there are cases where recognition applications have been made to get the benefit of the moratorium, and notice has been given to claimants in arbitration contexts who would lose the ability to pursue the arbitration without seeking relief from the court. And I would say that that person has a sufficient interest to hear from them. They're likely to be a creditor as well, so the issue probably wouldn't arise. Well, I'm very conscious of the time. Can I press on?
Please do.
Thank you.
Is that your third point?
Lord, this was really the...
Board of Insolvency Regs.
No, I'm not quite on to that yet. I'm coming on to that very shortly. I'm still on the point, which is that although recognition and assistance are distinct concepts, in a case such as this, we are not conflating the two in contending that Q&M have an interest which justified them being heard on the recognition application. The critical point, as I've made, is recognition was the springboard to assistance. Certainly, that's the way that the application was put, or a necessary step towards seeking assistance. And it can't be right that Q&M were bound by the recognition of the court without having an opportunity to appear before the court to argue that, in fact, the court should not recognise it in the first place. Now, I will now move on to an example in the context of the CBIRs. It's a case called Dalnyaya Step, and the reason I want to take you to it is because it came before two judges. First, Mrs. Justice Rose, as she then was, now of course a Justice of the Supreme Court, and then before Sir Geoffrey Voss, then the Chancellor and now the Master of the Rolls. Now, the judgments relate to a recognition order made in favour of a Russian liquidator or official receiver under the Cross-Border Insolvency Regulations 2006. As I know, at least my Lord Justice Snowden and my Lady Justice Falk well know, the CBIR were made in order to implement and give force of law in Great Britain to the UNCITRAL model law on cross-border insolvency. And the model law, with certain modifications, is set out in Schedule 1 to the CBIR, with Schedule 2 setting out the procedural rules. And of course, one thing that the model law permits is a foreign insolvency office holder to seek recognition in this jurisdiction. Recognition carries with it, in certain circumstances, an automatic moratorium, and in all circumstances, access to assistance of various types. And as I've said, the only reason it appears that we're not in CBIR territory in this case is because the proceeding in Russia was not a foreign main or non-main proceeding, because the bankrupt didn't have his commis or an establishment there. Now, the reason for showing you these judgments is because the application to set aside the recognition order in this case was made by persons, the hermitage parties as they're referred to, who were not creditors of the company in liquidation, but persons against whom assistance was sought by the liquidator after he had secured a recognition order. Now, the liquidator didn't argue in this case.
Sorry, where you could, did I miss the tab number?
I haven't gone there yet, so I'm just telling you what the case was about before we go to the judgments.
Okay.
It's Supplemental Authorities Bundle, tabs 1 and 2. I'm just introducing it at the moment because I can't go so far as to say that these judgments are authority for the proposition that the target of the assistance has standing to challenge a recognition application, because the standing point was not raised. But neither of these experienced judges considered that the Hermitage parties had no standing or queried their standing in any way. And we suggest there's no good reason for taking a different approach to standing in the context of common law recognition than in the context of the CBIRs. I want to start, please, then at tab 1.
So are you taking us to two cases under the CBIR where the point wasn't raised in support of an argument in a case which isn't under the CBIR where the point is raised?
Well, that's a slightly pejorative way of putting it. I'm going to do it briefly, but for good reason.
Right.
Given the nature of the application and the way that the judges approached it. There's a couple of sentences in the judgments which give a pretty clear hint in my respectful submission. If my lords and my lady could turn please to page 5 of the judgment of Mrs. Justice Rose, as she then was. You'll see that this judgment was given in response to an application made by the Hermitage parties for security for costs. And turning over the page to paragraphs 4 and 5, you'll see what applications the security was sought in relation to. Could I ask you please to read paragraphs 4 and 5 to yourselves? Then turning on please to page 10, I just want you briefly to see the introduction to the public policy arguments that were being run by the Hermitage parties. Can I, for this purpose, simply ask you to read paragraph 22 to yourselves? Moving on to page 13 and paragraphs 34 to 37, what you'll see from those paragraphs is that the recognition application had been made at a short ex parte hearing at which the history of the matter had not been set out in full for the court. And the Hermitage parties alleged that there had been a breach of the duty of full and frank disclosure by the liquidator's then legal team. For personal reasons, I'll just point out that the representation before Mrs. Justice Rose was different to that below, as paragraph 34 makes clear. Moving on to paragraph 64 on page 19 of the bundle, the judge considered for the purposes of the security application whether the recognition application was properly described as a proceeding. And at paragraph 65, which is important, she said this: as to whether the Hermitage parties can properly be described as the defendants of the recognition application, in my judgment they can. The model law and Schedule B to the CBIR clearly contemplate a number of circumstances in which there will be a party opposing the grant of the recognition order. First, there is the circumstance which is the one which has arisen here, where a person wishes to contend pursuant to Article 6 that the grant of the recognition order would be manifestly contrary to the public policy of the jurisdiction in which the order is sought. There are other circumstances in which a party antagonistic to the grant of the order or the conduct of the foreign representative may emerge. Article 4 of the model law contemplates a person affected by recognition challenging the grant of recognition if he can show that the grounds for granting it were fully or partially lacking or have fully or partially ceased to exist. Such an application can lead to modification or termination of recognition either altogether or for a limited time on such terms and conditions as the court thinks fit. At paragraph 69, the judge adds this: in these circumstances, it seems to me likely that if some of the background which I have described have been disclosed to Registrar Barber, she may well have adjourned the application and directed that notice of the application be served on the Hermitage parties, so that an inter partes hearing could be held to resolve the public policy issue before the order was granted. I note that paragraph 30 of the Unto Trial Guide comments that where Article 6 is an issue, this may be a preliminary question to be considered on an application for recognition. So the point there is that the judge thought that actually the registrar who heard the recognition application may well have wanted to hear from the Hermitage parties, notwithstanding that they were not creditors, but on the basis that recognition was the springboard to a Section 236 application against them. At paragraph 70, she goes on to say, if that had occurred, there can be little doubt that in substance the Hermitage parties would have been the defendants of that application and that they would have been entitled to seek security for costs of resisting the application of the recognition order. Mr. Nogotkov, who was the liquidator, should therefore be deprived of the advantage of having obtained the recognition order ex parte, obliging the Hermitage parties to bring an application to set it aside. At the end of paragraph 71, 5 lines up, the Hermitage parties are not seeking any separate relief themselves, and the set-aside application is purely a defensive stance taken against a recognition order, which Mr. Nogotkov accepts was sought and obtained in order then to bring the Section 236 application against them. And one sees the point that recognition is the springboard to judicial assistance, and it certainly appeared to Mrs. Justice Rose that the fact that recognition had been sought to enable the liquidator to access Section 236 against the Hermitage parties gave the latter an interest in the recognition application. We don't need to turn up the results, but in the end she did grant security for costs in favour of the Hermitage parties, including in respect of the application to set aside the recognition order. Now, on ICC Judge Briggs's approach, that would have all been entirely wrong because they would have had no standing. The judgment of the Chancellor, as he then was, is...
The trouble is you've got a difficult read of this because, I mean, because of the CBIR, the way it's set up with, first of all, an intention that a recognition application should ordinarily be capable of being processed and granted very quickly. That's expressly set out in the model law. You have you have an express facility, which we've seen, for persons who fall within, in fact, it's not just paragraph 25(1)J of Schedule 2, but I think there's actually a provision in the model law itself, Article 4, which suggests that people who might be affected by the grant of the automatic stay.
I think it's qualified in that way.
Well, okay, it may not be qualified. Okay. Find it, but certainly that's the primary circumstance in which it's become, it could arise, let's put it that way. And then you have an overlay of, therefore, cases such as the one that Mrs. Justice Rose referred to that I decided in OGX about full and frank disclosure, which often comes up in the context of why you're seeking recognition. It is to get the automatic stay in order to frustrate something that's going on.
Right. And
as a matter of process, as much as anything else, the court may decide, as I think Mrs. Justice Rose goes on to record what I said in OGX, rather than have a two-stage process of I'll grant recognition and then just have another hearing at which people can squabble about the effect of the automatic stay, is to roll it all into one. So there's quite a sort of procedural overlay under the CBIR, which I can see why you say some of that perhaps ought to be mirrored in common law.
Well, look, we're just looking at standing. Can it be right that if a CBIR application had been made, we would have had standing? But because they went at common law, we don't? Because the implications of that are that people might seek to avoid using the CBIR and the procedural overlay to avoid having people contest applications, which seems a slightly bizarre result. Plus, would one say that there's no duty of full and frank disclosure under a common law recognition application? Of course not. The procedural overlay makes no difference to that. Why does it make a difference to the question of standing? And on this application down the IS step, the Hermitage parties didn't know about the original application. They hadn't been put on notice of it. They have a right to apply to set aside. If you've got a right to set aside, you must equally have standing, if you do have notice of the application, to appear. The court heard from the Hermitage parties because they had an interest in avoiding being the target of a 236 application when there was a public policy reason why recognition shouldn't be granted. Why ask rhetorically, are Q&M in a completely different position because by chance the application was made at common law rather than under the CBIRs because the bankrupt didn't have his commune establishment in Russia?
It's not by chance. I mean, it's because the CBI, it maybe said this, because the CBI, you're not suggesting that we should write into the common law every provision of the CBIR.
No, my lord, I'm not, but I'm just suggesting that one would need a good reason why under the CBIRs the Hermitage parties were entitled to be heard, but under the common law, had there been a common law recognition application, they wouldn't be. What is the qualitative difference? And the fact that there are procedural rules, the fact that it may be that recognition applications should be made quickly under the CBIRs or whatever the precise point is, doesn't seem to me to affect the question of standing in any way, or certainly not materially.
Right, do you want to show us that there's the other case with
Tab 2.
Master of the Rolls as he now is?
If you could please go to page 30. The Chancellor sets the scene for his judgment in the first 5 paragraphs. It's probably quicker, I'm afraid, if you could read those 5 paragraphs to yourselves.
Yep.
Now, that was the context. I don't need to take you to anything, I think, for present purposes, other than paragraph 87 on page 50, using the number at the bottom of the page. Paragraph 87. In holding that the liquidator had breached his duty of full and frank disclosure, the Chancellor said this: in this case, Mr. Nogotkov intended, at the time he applied for the recognition order, to issue his 236 application against the Hermitage parties. He knew that they would say that his actions were political. That much is clear from his own press release of the 1st of August 2016. Article 6 of Schedule 1 of the CBIR will, of course, only be invoked in an exceptional case, but this was just such a case. The agreed facts are enough to demonstrate that Mr. Nogotkov knew or ought to have known that UK public policy issues would be raised by his request for the recognition order, and that steps that he intended to take in consequence of it, and the steps that he intended to take in consequence of it. He ought to have given the court the opportunity to consider whether Article 6 was engaged and whether the recognition order ought to be refused on the grounds that it would be manifestly contrary to the public policy of Great Britain, or at least whether it wanted to hear submissions on the point from the parties intended to be the subject of the future Section 236 application before determining if a recognition order was appropriate. So again, just like Mrs. Justice Rose, as she then was, said, the Chancellor indicated that he thought that the court should or may want to hear submissions for the Hermitage parties on recognition because they were the intended target of the Section 236 application that the recognition order was designed to access. My lords, my lady, my next topic was going to be to go through some of the cases that my learned friends...
Do you go so far as to say that in every CBIR case where an application for recognition is made and it's indicated or known to the applicant that they may be seeking subsequent assistance, that they have to give notice of the application to the target?
Not necessarily. That may be right. But
Where's the line?
well, if the recognition is being sought for a specific purpose, which is to target someone in a specific way, then ordinarily I suspect the court would think that it's appropriate to hear from that person. But the key point is this. It's not necessarily about giving notice. It's about that person's ability to object to recognition by way of appearing on the application if given notice, or by applying to set aside once the recognition order has been made. The test must be the same. Is this person entitled to make submissions on the point before the court? So my answer to my lord on notice is my answer. It may or may not be correct. But what's more important is the question, would anyone who is the express target of the assistance for which the recognition is sought have the right to apply to set aside and be heard by the court? The answer to that is yes. They may fail. It's not easy to set aside a recognition order. Down the IS step was a pretty extreme case. But the question is about standing and whether someone has an interest which justifies the court hearing from them. The question's not about notice. And we do submit that just as the hermitage parties had standing to and a legitimate interest in applying to set aside the recognition order in that case, and although the point wasn't decided, it's clear from the judgments that the court thought that they did, Q&M had a right to be heard on this recognition application.
Is the answer, and I think you'll appreciate why I'm asking you the question, because it has broader ramifications, but is the answer to the question the one which I think I may have given in AGX, but certainly is flavoured throughout these judgments, that if you're making an application for recognition and you know that you have an intention to use the recognition, either the automatic stay or you're going to apply for some non-automatic relief on the back of the recognition, you have a duty to bring that to the attention of the court at the recognition stage so that the court can then decide, do I adjourn this now and invite the targets to come and make submissions now, or I'll grant recognition with the ability for the targets to come and sit aside, so that you deal with the question of full and frank disclosure in that way. Your point being that on any footing, the person who's the intended target would be somebody who would be entitled to be heard at whatever stage the court would decide.
Absolutely right. My lord, that's down the IS step. I was going to have a section of my submissions looking at some of the cases under section 1685 of the Insolvency Act and Rika Gold and all the rest of it. I'm going to do that in a shorthand way by reference to ICC Judge Briggs's own decision in a particular case, because I don't have time to do it otherwise. The case is one which will be familiar to my Lady Justice Falk. It's called Sturgeon Central Asia. It's in volume 2 of the Authorities Bundle at tab 33. So this is a decision of the same judge from 2020, where he took a very different approach to the authorities. Now, this was an application...
Sorry, give me the tab again.
I do apologise, 33. This was an application to terminate recognition of a solvent winding up in Bermuda, and the issue was whether the CBIR applied to a solvent winding up has been held to be the case when recognition was granted by my Lady Justice Falk. The termination application was made by Mr. Carter, an independent board member of the company prior to it going into liquidation. The application to terminate recognition was successful, Chief ICC Judge Briggs concluding that solvent winding ups do not fall within the scope of the CBIR. But for present purposes, and I'd like to gloss that as much as possible, what matters is his approach to the question of Mr. Carter's standing to seek termination. Now, for that, can I ask you please to go to page 860 of the judgment, and you'll find towards the bottom of the page, section B, the standing of Mr. Carter to make the application to terminate. Now, you can see from paragraph 48 that Mr. Curl, appearing for the JPLs who had been recognised, the joint provisional liquidators of the company, opposing the application for termination, Mr. Curl argued that Mr. Carter did not have a legitimate interest to make the application because he had no interest in the winding up. Exactly the same point that's relied on by my learned friends in this case. And as the judge records in Mr. Curl's submission, the only persons affected by recognition are those who have a financial interest in the outcome of the insolvency process, and Mr. Curl relied upon Rika Gold for that proposition. As you'll see from paragraph 49, Mr. Curl also relied upon the Deloitte and Touche line of authorities in relation to who is a person aggrieved by the actions of a liquidator. And can I ask you please to read paragraphs 49 and 50 to yourselves?
To 49 and 50.
Thank you, my lord. Now, the judge rejected Mr. Curl's submissions, which you may find surprising when you come on to look at the judgment in arguments. But can I ask you to read paragraphs 52 to 54 to yourselves, and then I'm going to highlight the key points that flow from that. But paragraphs 52 to 54 really encapsulate the way in which we put our case and the approach to who has standing for the purposes of a recognition application.
Right.
And the first point I should make is when I was discussing who could apply under the CBRs with my Lord Justice Snowden a few minutes ago, I said Article 4. I meant Article 17.4, which is the provision that's referred to. And the judge faithfully recites the key words, which are a person affected by recognition. Those are the words. It doesn't go beyond that. There's no further qualification or conditionality about the words used. Now, we submit that what the judge here does is quite right. He distinguishes the authorities relied upon by my learned friends in seeking to work out, and he does so because in seeking to work out who a person affected by recognition might be, one needs to focus on the consequences of a recognition order being made. The judge made the point, quite rightly, that recognition led to certain powers being available which would not otherwise be available, and he accepted that a person who's exposed to the exercise of those powers has an interest in recognition for that reason. And in paragraph 55, which I haven't asked you to read, the judge determined that Mr. Carter should be given permission pursuant to paragraph 25(1)J of Schedule 2 to the CBIR, the rule that I took the court to earlier, to be heard. Now that provision is in the authorities bundles. I won't take you to it, but if you'll note, it's at tab 2 of volume 1 of the authorities bundle at page 37.
So Mr. Carter was a director,
Former director.
former director. So what was his, I mean, what was in substance his beef? What was he concerned about?
My Lord, I'm not entirely sure. It's the analysis and the reasoning that is critical, not why Mr. Carter in this case had standing. What's critical?
No, sorry, I understand you say it's the analysis and reasoning, but I'm trying because
I'm not sure it's made clear, my lord. I did look for all references to Mr. Carter to try and sort of puzzle this out.
Well, I'm glad, that's what I was trying to do, but I'm glad you didn't get the success.
And I'm afraid I can't help further with that. But what is critical for present purposes, and I appreciate this is in the context of the CBIR's, not common law recognition, but the same, in my respectful submission, applies. But one is not helped by looking at what the court's approach is to who has a sufficient interest in particular circumstances to be before the court, whether it's on a winding up petition, whether it's on an application by a person aggrieved by a liquidator's decision. One has to look at the nature of a recognition order and what it leads to, what the consequences of recognition are, what can be accessed as a result of recognition to test who the court should consider has a sufficient interest in being heard from.
I understand you're saying we're not dealing with the CBI case, but it's just, it was curious, in paragraph 55, he gave permission to Mr. Carter as a person affected by recognition, irrespective of the fact that he was a director of Sturgeon at the time it was wound up. And I'm just thinking, if he wasn't affected by recognition because of his status as a director, what was his,
Lord, at the moment, I
Just
can't
don't know.
help with that because I haven't seen an explanation in the judgment. Now, I may have missed it, like my lord, and I can have another look over the short adjournment, but I can't answer that.
Okay, so that's your case by analogy, and you say that deals with the other line of cases on which Mr. Davis relies.
Yes, and on which the same judge relied in his judgment below, which I'm going to turn to now, if I may.
Yeah.
Now, you'll find that judgment at tab 23 of the core bundle. And I'd like to ask you please to turn to the relevant section, which is on page 304. Towards the bottom of the page, the heading is the determination of standing. And by way of...
Sorry, can you give me the...
I'm so sorry. So it's tab 23 of the core bundle, page 304.
Thank you.
And could I ask you please to read paragraphs 33 to 36 to yourselves? Now, just to pick up on one point on paragraph 35, three possibilities were identified by the judge, but in fact there's of course a fourth possibility. which is someone with an interest justifying their appearance, can be heard by the court, including because they're a target of the assistance which is sought through the recognition. That wasn't one of the three options the judge considered possible, notwithstanding his decision in Sturgeon. At paragraph 37...
Wait, yeah, okay, let's be fair to the judge for a second. Did anybody draw his attention to Sturgeon? Because he says without the benefit of any authority.
Well, this is a bit of a spoiler. It's paragraph 43 that we're going to come on to in a moment. He refers to that, and you'll see how he deals with it in a moment.
So, but was the point, the argument that you're making now, made to him, and he just ignored it in paragraph 35?
Well, probably not in quite these terms, but of course this wasn't an issue that arose for determination under the four things listed by Mr. Justice Mead. So, from Mr. Edwards' perspective, this is not something that he had come to court prepared to argue about.
I mean, paragraph 35 is the judge recording what he put to the court on the second day. So that's him. There could have been all kinds of other options, but he is simply recording here the options that he thought there were. He then said he invited responses, and there's the rest of the paragraph.
That's right.
I mean,
can I carry on?
The judgment makes it quite clear this was a judge-led point.
Absolutely. There's no question about that.
Yeah.
So then at paragraph 37, he says there are some parallels to be drawn from other areas of company insolvency law. First of note is that only a member or creditor has standing to rescind a winding up order. Those are parties that have an economic interest in the company. Secondly, a member or contributory other creditor is dissatisfied with the office holder's decision on a proof of debt has standing. Thirdly, on an annulment application, the applicant must satisfy the court they have some kind of legitimate interest, direct or indirect, in applying for an annulment of another person's bankruptcy. And then fourthly, he goes on to look at Brake and Cheddington and effectively looks at some of the cases which the judge had identified in the previous judgment in Sturgeon. He then says at paragraph 42, Q&M were unable to respond to these examples when I asked what interest they have specifically in the bankruptcy, which we say is not the right test. He then says, in Bailey and others, former representative of Sturgeon's Central Asia Balance Fund, the case we just looked at, the court granted recognition in an ex parte proceeding to Bermudan liquidation proceedings which were taking place on Bermudan law just and equitable grounds, notwithstanding that the company was demonstrably solvent. That judgment was reviewed by myself in the decision we've just looked at. I held that for proceedings to be recognised in England and Wales as foreign proceedings under the CBIR, they must relate to the resolution of a debtor's insolvency or financial distress. The foreign proceedings must be pursuant to a law relating to insolvency, and where such law permits solvent companies to be wound up, a solvent winding up is not a foreign proceeding and consequently not suitable for recognition. The prior issue that needed to be decided in Sturgeon was whether Mr. Carter had standing to make an application. I referred to Deloitte and Touche, where the Privy Council recorded that the only persons with an interest in insolvent liquidation are the creditors, and the contributories if the liquidation is solvent. Re Eden note, which concerned an application to set aside a decision to assign a cause of action by the liquidator, by the person aggrieved. And Mohammed and Morris, where the court found that a surety did not have standing to make an application to set aside a decision of the liquidator to enter into a settlement agreement. And then he says, in my judgment, it's not open to anyone to oppose the application. A person must have an interest in the bankruptcy. Equally, the bankrupt may have an interest, but other persons such as creditors will have a legitimate interest in an application to recognise a foreign office holder. A party that has tangible economic interest in the bankruptcy and acting in the same capacity as that which gives rise to the tangible economic interest in making an application will be sufficient. Consistent with the approach taken by the Supreme Court in Brake, this court should permit only those who have a legitimate interest in the bankruptcy to have standing for the purpose of opposing a common law recognition application. Such persons will include creditors, but not a party who is a defendant in proceedings where a foreign representative seeks to be a claimant. I accept that such a person will have a commercial interest in the outcome, but they have no legitimate interest in the bankruptcy. So that's the decision that led to the order that we complain about.
How much, sorry, it's the same sort of point I just made. How much of this was actually argued out in front of him?
Oh, very little. I mean, I wasn't there, but I assume very little on the basis that this was a point raised by the judge at the hearing, which hadn't been on the agenda. But he refers to his own decision where he takes a different approach to those authorities and takes the right approach in terms of asking the correct question. And in this judgment, he refers to his own decision, doesn't deal with the relevant part of it on standing at all, and reaches a very different conclusion. And the only point, my lord, is this is where he went wrong, and actually the approach that he had taken in the Sturgeon case is the right approach.
Okay, well, I understand I understand that, but I'm just trying to get for myself whether the arguments you're now putting forward and we're hearing were effectively addressed to the judge, or whether in effect he formed a view, didn't hear argument, and then went away and wrote up a judgment, off his own back.
Well, as I understand it, the point was not properly argued. Mr. Edwards tells me, and he was the advocate, I wasn't there. And that the judge gave, I think, an extempore judgment, which then wasn't produced. And he then later produced this written judgment.
Okay, so he announced a decision and then gave reasons to follow.
I think it goes beyond that, as I understand it. It may not matter, but as I understand it, he did give an extempore judgment,
okay, but
not just reasons.
But in a sense, the possibility of drawing to the judge's attention the consistency, as you put it, between what he previously decided in Sturgeon and what he was now deciding was not. I mean, that wasn't explicitly done at a hearing.
No. Absolutely not.
No.
Well, we have a transcript of that hearing, don't we?
Yes, it's one of the least usable documents I'm afraid I've ever come across. But, my lord, there's...
Okay, I have not. I mean, others may have done.
I did have a
Well, you showed us a part of it.
I did, I showed you 4 lines.
Yes.
My lord,
It's,
the point is...
it's unusable because...
Because so much is inaudible that it's difficult to make much sense of it.
So it's another triumph for HMCTS.
That may be right. So, my lord, it is right to say that the judge did not have this judgment.
He did deliver an extempore judgment, didn't do the transfer.
What are you reading from?
It's explained in our skeleton.
Yes, in our skeleton for this appeal, which is at page 350 of the core bundle at tab 28,
Yeah.
it records that the judge delivered an extempore judgment, but in the event did not approve the transcript of it, but instead, on the 23rd of January 2025, handed down a written judgment addressing standing and recognition. That's what I'm told happened. But in answer to the simple question, was the argument I am now advancing made before the judge? Answer, no. Reason for that, because it hadn't been on the agenda, although I have to say it was floated on day 1 and this was day 2. I should make that clear.
Yes, it was floated on day 1. And were these authorities then scrambled together overnight and produced on the second day?
No, they weren't. I think, I assume that the authorities referred to in the judge's judgment were authorities that he decided to include in his judgment that hadn't been before the court.
Yes.
I'm told that's right. And I do query the inclusion of the way in which the Sturgeon capital judgment is dealt with in this judgment. But all of that is, in a sense, by the by. The critical point, because this is an appeal against the order, is that it was wrong to conclude that we had no standing. We plainly did, for reasons which follow from the judge's own analysis in his earlier decision in Sturgeon. Lord, I have a few minutes left. I think we started about 5 minutes late. Can I extremely briefly address the other grounds of appeal?
Of course.
They are far less important, but just so that you have submissions made on them. I've addressed fully ground 1. Ground 2 is that the judge erred in law or in the exercise of his discretion by determining the recognition application in the absence of any other party. And as to that, if the recognition order binds Q&M, then we say, ground 1, it can't be right that we weren't there. So to that extent, we're back to ground 1. If the recognition order doesn't bind Q&M, then, and I'm accepting for purposes of this appeal that it does, but if we were wrong on that and it doesn't, then the court acted in vain in making an order that served no substantial purpose. But the court should proceed on the basis that the order is binding, and it's ground one that really matters. Ground 3 relates to Q&M's application to challenge the court's jurisdiction in relation to the relief sought in paragraph 2A of the recognition application. That relates to the shares in Q&M themselves. But I am told that the judge never gave judgment on that application or identified any reasons for dismissing it. Nevertheless, the order at tab 21 of the call bundle records on page 286 at paragraph 1 the dismissal of that application. Mr. Edwards tells me that rival versions of the draft order were sent to the judge. His didn't include a paragraph dismissing that application, and the Learned Friends order did, and the ICC judge included that order without any debate on the matter.
So there were no oral submissions on
The CPR 11 application was fully argued and it was a judgment.
It was fully argued, judgment was reserved, judgment was never given, and the order was made.
There were submissions.
Yes.
CPR 11, yes. We spent day one on CPR, we spent the afternoon of day one.
The afternoon of day one apparently was spent on that, but there is no judgment, just an order dismissing it. Ground 4 is that there was a serious procedural irregularity in that the judge raising and determining the standing issue in the way that he did, notwithstanding that Q&M had been made respondents and the court had given permission to serve out. And we accept on that the arguments on standing have been fully made before this court. If we prevail on the appeal, then the point falls away, ground 4 is unnecessary. And if we fail, well, then there's no point remitting the matter to the judge. So,
Just to be clear, going back to ground 3, I'm just trying to get my head around that.
yeah.
That's the paragraph 2A point that you said it's just these shares are not in the jurisdiction. It's got no. What has this court got to do with anything?
Yes.
And you're saying that. So when it says the judge erred in law in dismissing the CPR 11 aspect of the appellant's application dated the 26th of November 2024, that's to do with paragraph 2A of the
Exactly.
original application. And the basis of the argument was these are not shares located in the jurisdiction.
That's precisely so. I showed you when I was showing you paragraphs 3 to 6 of the order on costs. We then looked at 1 and 2. Paragraph 1 was the dismissal of that application for which no judgment has ever been produced.
Right. And so what do you say we should be doing about that?
Well, I mean, theoretically, that application should be remitted back to the judge to determine.
So it wasn't a trick question.
No.
I was just asking you. Right.
So you're not asking us to decide it.
No. The judge has heard full argument on it, as I understand it, and not produced a judgment.
Really, your basis of that ground is a procedural one. He didn't give a judgment.
Yes.
The RM invites them to decide it. It says it's right.
Well, yes, I'm reminded the respondent's notice asks you to decide that the judge was right in dismissing the application. So I'll leave that between Mr. Davis and Mr. Edwards to deal with.
In terms of your appeal, it's
terms of my
really
appeal.
a procedural challenge that there was no judgment.
Correct. I've just explained why ground 4 is included, but doesn't really take us anywhere. And then ground 5 is the order that we pay the costs of Mr. Vesnin thrown away by our participation in the application that we were made respondents to, and he obtained permission to serve out of the jurisdiction. Obviously, if the appeal succeeds, well, then that cost order should be reversed. But we do submit that even if you are not with us on ground 1, it was a fairly extraordinary decision to penalise us in costs for participating on an application to which we were named respondents and in relation to which the court had decided to give permission to serve out, and an order that was made beyond the court's reasonable exercise of its discretion.
Well, wait a minute. If we're against you on the main point,
Yes.
then your participation was unsuccessful for good reason. I mean, sorry, there was a good, in a sense, if we were against you on the main point, you appeared at a hearing and made points which you had no standing to make.
Well, but my lord, on the basis we were joined as respondents,
It doesn't follow.
leave to serve out was given.
But it doesn't follow that if you're joined and leave server is given that you have a free run to come and say anything you like.
Well, Lord, but it doesn't mean that we should end up having to pay the costs of the person who brought us to court for the purposes of seeking to bind us to a particular order.
Well, I mean, it may be dependent. It may be a question of which costs. I mean, in a sense, if they sought permission to serve out.
Yes. And you saw the evidence and the basis.
I mean, it's slightly hypothetical depending on what you presumably decide on the first point. But
It is.
But it.
It's entirely
Are you saying that, in a sense, under no circumstances could you be made the subject of an order for costs because you were invited to the hearing?
Well, my Lord, I would submit that it is perverse when an applicant brings a claim against a respondent, obtains leave to serve them out, and doesn't then make some sort of application that they be bound by the order but not heard on it. The respondents are then penalised in costs for the costs that the applicant incurs as a result of their participation until the judge of his own motion decides that the respondent shouldn't be there, having given permission to serve them out.
Okay, so, I mean, you're tying it very specifically to the facts of the case. You're not making any general proposition that
No.
a party who's served and therefore is invited to attend a hearing.
Costs orders are sensitive to the facts. On the fact of this case, it was a decision that fell out with the generous discretion of the judge.
There's always a much safer submission on any argument as to costs, rather than identifying principles or guidelines or tilting the playing field, and this applies across the board, because they never do.
My Lord, I'm not attempting to make a broader point.
I understand that. You're saying on the, what might be regarded as the unusual facts of this case, even if we're against you on the other points, you say, well, it can't be right that I pay these costs.
Oh, that's right.
Yeah.
And I'm talking about the costs ordered against my clients below.
Yeah. Okay.
Unless I can assist further, those are our submissions on the appeal.
Thank you very much, Richard. Thank you very much. Right, yes, Ms. Davis.
I'd like to pick up first, if I may, the whole subject of the CBIR and my friend's reliance by analogy with the way in which things happen under the statute and the statutory scheme, which is represented by the CBIR. And for that purpose, could I start by asking you to go back to the supplementary bundle of authorities, which is the bundle that's come in recently, with those Dalanya cases, included. And you were taken to the judgment of Mrs. Justice Rose, she was. May I ask you to go to page 7 of the bundle, which I hope takes one to paragraph 10, which sets out Article 17.
Yeah.
And my Lord Justice Snowden mentioned the statutory imperative in 17.3. We see it there in the middle. An application for recognition of a foreign proceeding shall be decided upon at the earliest possible time. So that's the overriding direction. And the way that the structure of the CBIR is then in 4, that if there's a subsequent modification or termination application, then that can be brought by, quote, a person affected by recognition or his own motion. And so that the overall approach in that scheme deal with status very quickly, the earliest possible time. And as the editors of Seeley point out, that doesn't involve attacking foreign judgments. And that way, the status of the insolvency holder is established or not. If it is established, we know that there are some rather wide-ranging and immediate statutory effects. And they are mentioned only by way of summary by Mrs. Justice Rose over the page 8 of the bundle, paragraph 12 of her judgment. I won't weary you going through them all, but it's just worth reminding that under the CBIR, unlike at common law, a recognition order has very wide-ranging effects. That is the simple act of recognising the status of the foreign representative. For instance, at 12.2 of her judgment, a stay and suspension comes into effect of the same scope and effect as if the debtor had been made bankrupt in effect under an English bankruptcy order. Then, to use a very effective phrase that my own friend used, the toolbox, as he called it, that's Roman numeral 3, is open, so the Insolvency Act becomes available to the foreign representative, and so forth. And so there's a marked contrast between what is going on there under that statute and the very limited effect, very, very limited effect of recognition simpliciter at common law. Put shortly, that there is none of those consequences. And so it is a very different regime. It is not at all front-end loaded. The threshold or the trigger, namely the appointment, is thought to happen, as it were, almost as a matter of course. I'm not going to go any further than that, because in fact there's a presumption there's a presumption of regularity, as we know, within the CBIR as well. And there you'll notice, going back to paragraph 10 of Mrs. Justice Rose's judgment, 10.1 says subject to Article 6, and that's the public policy, manifestly contrary to public policy of Great Britain exception. A foreign proceeding shall be recognised if, and then one. Sorry, it's my fault. I did that too quickly. Paragraph 10, Article 17 is set out. 17.1.
Yes,
Subject to Article 6, a foreign proceeding shall be recognised if. It's a straight and narrow gate. You go through A, B, and C, and D, and you get your recognition, and that will happen at the earliest possible time.
But it is the case that though hidden within paragraph 1, as you directed us to, there can be some very difficult questions. Indeed, the OGX case was just such a case. I mean, where the question is it a foreign proceeding within the meaning of Article 2? And is the person applying a foreign representative within the meaning? I mean, those are not sometimes straightforward at all.
I agree entirely.
OGX arose because, from memory, the applicant didn't include within the statute that they put before the court, I think it was Brazilian statute.
It was.
The relevant provision that actually made perfectly clear that they were not foreign insolvency proceeding within the meaning of the CBIR. In fact, they specifically excluded it in the document, which was
the crucial 3 points.
So, you can't have a battle at stage 1.
That wasn't stage 1, though, of course, and this is the crucial point. 3 things about my Lord's case, OGX. First is the applicant was a creditor. Second, it was an application after the event to set aside, as envisaged by this process. And thirdly, the English court itself had been misled, such that its order was void ab initio, to use the words of in the cases, because there had been very substantial breach of full and frank disclosure obligations.
Just on that point, and your point that it should be done quickly, we were taken earlier to paragraph 69 of Mr. Justice Rose's judgment, which talks about, well, if some of this material had been flagged, the registrar might have adjourned. How does that fit?
Well, because this is after the event.
Well, no, it's not, because though she's saying you might have adjourned the ex parte application.
In order to hear.
Yes. So 69 is not talking about setting aside after the event. And equally, I can't, when it comes to standing, should there be a difference between quick recognition and setting aside, an application to set aside?
Well, the idea is that recognition, at common law, is only to do with status. That is not something that should involve a 6 to 12 month trial schedule with a view to seeing whether a Russian order was the subject of political or the result of political interference. That's not how it should work. The foreign representative needs to know whether his status in this jurisdiction is recognised. There may well be all sorts of issues down the line, and there may even be an application to set aside the order recognising him on grounds of lack of full and frank disclosure. But in the meantime, and the onus is on him, of course, to make full and frank disclosure.
What has to be done is the application has to be decided upon at the earliest possible time. If there are substantial disputes about the satisfaction of the criteria, it's just not possible to decide them fairly at an earlier stage. That's one way of reading that requirement. That requirement, I think, is there to just try and ensure that courts just don't sit on applications.
But it is interesting, if I may say so, that Article 17.4 does talk about subsequent modification or termination. And the emphasis is on that second stage as being a time when, in the events which happen, somebody could come in and suggest that recognition should be modified or terminated. That's the structure of the CBIR. The emphasis is on having an entry point which is simple and easy, hence the imperative. And I accept entirely that there may be issues, of course, but there is a strong duty of full and frank disclosure, and all of that combines to explain how it should be dealt with at the earliest possible time, because the court proceeds on the assumption that it has had full relevant disclosure made to it.
So you're really saying the application for recognition under the CBIR should be ex parte. That's the way you're putting it.
It often is.
Well, I think you seem to be going further and effectively saying it should be. And that others can come in only in an application under Article 17.
Well, we know, and we've got it in the authorities bundle, I think, we know that the statute has decided who the persons are who are entitled to come in on that stage. We get that, it's the authorities bundle, volume 1, page 37.
Yeah. This is the provision we were
Yes, so this is Article 25 again. And there is, as sub J would suggest, a menu, it's page 37, of persons who may come forward. And none of those, the only time I think I'm right in saying that one could fit a creditor into that would be in J. Quite a long list of persons, and including the debtor. And then at J, it's with the permission of the court, any other person who appears to have an interest justifying his appearance. So that would, a creditor would need permission. And so far from being a sort of free-for-all, this is a tightly and finely calibrated sort of process where those promulgating this legislation, this model and the model, have thought through who it is that may appear at the inception, and even a creditor, as I say, needs permission because at that stage it needs to be dealt with quickly and efficiently, and it does not envisage at that stage there being some sort of grand trial about public policy unless it is manifestly contrary to public policy. And the word manifest there does all the work.
So that's under the manifestly word is obviously in the CBIR.
Article 17. I'm so sorry, Article 6. That's in Mrs. Justice Rose's judgment, her paragraph 11.
Yes.
And in a sense, although it needs to be stated, it is the case anyway that no court would make an order which was, quote, manifestly contrary to the public policy of Great Britain.
Mhm.
But on no view of life does this case fit into that category if this had been a CBIR case. It's just not even close. And so, even under the CBIR, we would say that, and the editors of Seeley say this, that the decision to grant recognition should not involve an examination of the merits of the foreign court order or decree. And that's plainly brought out by the structure of the model law and the rules. And in my Lord Justice Snowden's case, again, it was a creditor after the event coming to court and saying, you have misled the court and abused this process because you really wanted for your own private gain to obtain this moratorium. And had the true facts been told to the court, there is no way on earth that the court would have made the recognition order. And the facts were so strong that the foreign representative, as it were, caved in, and nevertheless, in the interests of wider interests, Sir Geoffrey Voss gave his judgment. And so the gist of all of that is that whilst we say that a recognition simpliciter at common law is a long way away from the recognition under the CBIR in terms of the nature and effect of both. More importantly, even under the CBIR, what Queeld and Maisper were attempting to do in this case would not have been countenance. They would not have had standing. They would not have been given permission to appear. May I now address, just before the short adjournment, the circumstances in which the application came to be made by way of response to...
Test that.
I'm so sorry.
To take the example of the foreign company that is a defendant to arbitral proceedings in the I'm just going to, because that's the classic sort of situation that arises with this sort of stuff. So you have somebody who's got a contract with the company, is commenced arbitration proceedings in London. The company goes into a foreign insolvency process, and an application is made for recognition of the foreign insolvency process here, including with the express intention of invoking the automatic stay to stop the arbitral proceedings in London. And the reason for doing that is that the claim of the claimant and the claim in the arbitral proceedings can equally well just be pursued by a proof of debt process in the foreign jurisdiction, and it shouldn't be the subject of continued litigation or continued arbitration in London, which is very expensive for no good reason, just to use the insolvent estate.
Yes.
Are you saying that, are you saying that in those circumstances, the person who's brought the arbitral proceeding has no standing to appear either on the application for recognition when made in the first instance, or subsequently to say that it ought to be, that the automatic stay ought to be varied?
Starting, assuming those facts and that it's common law, and then I'll deal with CBIR. At common law,
Start under the CBIR first, will you?
then I will. Under the CBIR, that would be a creditor, and the creditor would apply for permission under J, we've seen, and the court would have to evaluate the justification. That's the statute. Under the at common law, as the judge said, it's a creditor. This creditor has the right, the standing. It's got a legitimate interest in the bankruptcy. That's where we reach our examples in our skeleton argument, where we're trying perhaps not successfully to tease this out, because what we try to do in, I don't know whether you have our skeleton argument to hand, paragraph 54.
64.
I think our skeleton's in tab 29.
Yep.
It's on page, I hope it's on page 380. I'd like to go in the core bundle.
Paragraph.
54.
Yeah.
And we give some examples here. So getting away from Russia, the first example is we assume that B, a French citizen, unsuccessfully resists bankruptcy proceedings in France. So he's the debtor, whilst also suing a debtor in England for sums due under an English contract. B's French bankruptcy trustee applies to the English court for recognition of common law and, if recognised, assistance in the form of a direction authorising him to take over as claimant in B's English proceedings against the English defendant. Now, the English defendant isn't a creditor, so he's not a stakeholder in B's bankruptcy. Therefore, he has no legitimate interest in opposing recognition of T as the duly authorised bankruptcy trustee. That's an internal issue in the French bankruptcy, in which he does not have a voice. But he certainly has a voice at the assistance stage, and we set out the reasons for that under the by contrast. And it's bringing out the fact that, just as in the case of Queeld and Maisper, they are not creditors. Whereas in my lord's example, you would have a creditor, and he's got every right to say, what's happened to this company? I'm in the middle of arbitration proceedings. I'm making a claim against it. I have a very real interest in this apparent insolvency, which I would like to challenge.
Yeah, I understand why my case was, you say, not to point, and it's the opposite way around to the current situation. So let's take your example, although perhaps we can use a corporate, I mean, let's just use, if we can, rather than a French citizen, a French company, but does it matter?
It does matter in some ways. That
I'm just trying to use your example and then apply the CBIR.
Sorry, forgive me, of course.
Yeah, I was just trying to say, well, let's apply the CBIR to it.
Yes, the same result. So far as recognition is concerned, which must be dealt with as early as possible, you've got no say in the matter. You wouldn't get permission, not a creditor, not involved. But on assistance, very different.
I think we'll probably come on to it. I'm struggling a bit with one aspect of your distinction between recognition and assistance, because if recognised, as I understand it, the effect of the Russian bankruptcy order is that all the movable property in the jurisdiction is automatically vested.
That's not an issue in this case.
Yes, but so to take this example,
Yes.
yes, go back to this example, what particular assistance would there...
My lady,
would
if
there
one
be
carries
that
on.
You're trying to draw...
So if one looks at the by contrast, if T is recognised, depending on the circumstances, the English defendant might well have standing to be heard on T's application for assistance against them. That is to say, on the question whether T should be substituted as claimant.
I understand that in a sense, but I'm trying to understand better what that really means. If there is a valid recognition, why on earth wouldn't the court substitute in those circumstances?
Well, the chances are, this is only addressing standing. This isn't addressing the result. I mean, I'm with you, as it were, that the court is likely to say, well, you now stand in the shoes and
Put
so
it another
forth.
way, why would it not?
Well, because it could be said by the defendant, well, I have countless cost orders against this bankrupt now. I'm now going to be litigating against a foreign trustee. I want security for costs as a condition of any assistance, et cetera, et cetera. I mean, there could be all sorts of reasons, and they would be legitimate concerns. But that's at the assistance
But
stage.
if you didn't need the court's assistance, you're assuming, yes. But there could be other situations outside a litigation context where there's really no conditionality or no potential conditionality like that.
It's difficult to think of one.
You show you're recognised. The assistance is that you want that piece of movable property that's in a bank vault. Do you need more than showing a recognition order?
If there are movables in the jurisdiction, and this is all ancient common law and no more, then there is a presumption of automatic vesting.
So
That's not this case.
I realise that, but I'm just trying to understand conceptually. In that sort of situation, can you not just tip up with your recognition order? You don't need any more particular assistance, do you? You just show the bank.
In reality, you would end up issuing proceedings. That's how it would work. And off you go. That's what happens in all of these cases. But our submissions, I'm sorry, I've noticed the time, are brought out and can be seen very neatly once one compares our case to the CBIR, because it shines a light on the very narrow and simple aspect of recognition versus assistance at common law. To use, I think it was Lord Walker who said it's just about status. My Lord Justice Snowden said yesterday, "Are you who you say you are?" That's recognition.
All right. So after the short adjournment, you're going to come to the circumstances in which the application was made.
Yeah.
Fine. Okay. 2 o'clock.
All rise.